abatement. So, for a crime, actus reus and mens rea are two requirements. There must be an actus reus or mens rea. An act, intentional act, and with an intention. That is, with an evil intention, guilty intention, evil intention. This abatement is an offense. Sometimes we say it is an inchoate crime. Inchoate crime. We say conspiracy also. That is inchoate. It is not complete, but it started. So here, so that's why sometimes you get a question: what is inchoate crimes? This abatement or conspiracy, criminal conspiracy, are two inchoate crimes. So abatement of a thing that has been defined in section 107 of the Indian Penal Code. What it provides? A person abates the doing of a thing. Here offense is not there. It is used that a person abates the doing of a thing who first instigate any person to do that thing. Instigating somebody, persuading somebody. First, a person abates the doing of a thing. First, three conditions. In three ways there may be abatement. First, when he instigates a person to do a thing. Secondly, engages with one or more other persons. He engages with another person or with more than one person or persons in any conspiracy for the doing of that thing. In any conspiracy for meeting, conspiracy of doing that thing. Not only that, if an act or illegal omission takes place in pursuance of that conspiracy, in order to the doing of that thing, then only he engages himself with another person or with one or more persons. What for? For doing of that thing. For doing of that is conspiracy. And if an act or illegal omission, engagement not sufficient, engages himself with one or more person for doing of that thing, and in consequence, and if an act or illegal omission takes place in pursuance of that conspiracy, merely engagement will not be an abatement. If a person engages in conspiracy with one or more persons, and in pursuance of such conspiracy, any act or illegal omission takes place, and in order to the doing of that thing, not only that, in order to doing of that thing. So first thing you should understand what is abatement. Abatement will take place in three ways. First, who instigates another to do a thing. First. Secondly, when a person engages in conspiracy with another person or with more than one person, and in pursuance of such conspiracy, any act or illegal omission takes place for the purpose of doing that thing, then that will be abatement. Third is that intentionally aids by any act or illegal omission the doing of that thing. Intentionally aids, helps, intentionally aids by how? By any act, either by an act or illegal omission. Illegal omission, you should understand. What is illegal omission? The doing of that thing. So first, instigates. In three ways there will be abatement. A person is said to abate a doing of a thing. First thing, when he instigates. Instigates means actively. There must be an intention. With an intention, he instigates. Who instigates any person to do that thing. Sometimes this suicide note, basing on a suicide note, an offense is registered for abatement of suicide of that person. Most of the, in many cases, you find somebody writes somebody's name that he is responsible for my death and I'm committing suicide because of this. Whether that will be treated as abatement. So here there must be an intention. Unless there is instigation means what? There must be an instigator actively with an intention is instigating for committing doing of that thing. Suppose a person says to his a person says to his friend, I want to break the ATM. The other friend in a joke says, yes, you go and break it. And thereby he broke the ATM. He committed an act. Will it be treated as instigation? The answer is no. There must be an intention. Intention of instigating the doing of that thing. So here is suicidal note. It is very weak piece of evidence because there must be immediate cause for the suicide. Suppose a person has prepared a suicidal note, after 1 month he commits suicide. How come that will be taken as consideration that he had abated the suicide by instigating a person to commit something, doing of that thing. So instigating is very important. Instigating must with an active intention, knowingly somebody with intention is instigating a person to do something. If instigation is second, if a person engages in conspiracy. So what is conspiracy? That is in section 120, we find this conspiracy, criminal conspiracy has been defined. 120A defines criminal conspiracy. What it says? When 2 or more persons agree to do or cause to be done. Agree. 2 or more persons, they agree to do or cause to be done. What? An illegal act or an act which is not illegal by illegal means. Such an agreement is designated as a criminal conspiracy. Agree to do an illegal act or an act which is not illegal but an illegal means. Such agreement is designated criminal, provided further provision is there. Mere agreement to do an illegal act, mere agreement to do a lawful act by illegal means will not be treated as a criminal unless if provided that on agreement except an agreement to commit an offence shall amount to a criminal conspiracy. So only agreement to do a criminal offence to criminal an offence, an agreement to commit an offence will be treated as criminal conspiracy unless some act beside the agreement is done by 1 or more parties to such agreement in pursuance thereof. Only an agreement to commit an offence will be treated as criminal. But other cases that will not be treated as criminal conspiracy unless some acts beside the agreement to do an illegal act done by 1 or more parties to such agreement in pursuance of that conspiracy, pursuance of that agreement. So it is immaterial whether the illegal act is the ultimate object of such agreement or is merely incidental to that object. So very criminal conspiracy, it is very difficult to understand what is criminal conspiracy. Sometimes loosely it is used. In many cases, criminal conspiracy 120B is that is included in most of the cases. That is criminal conspiracy. It is very easy to drag somebody to a criminal offence by including that is making accusation against him that he committed criminal conspiracy. He gives abatement. So abatement of a thing, abatement, there must be instigation. Instigation means there must be some intentionally doing, instigating somebody to what? To do that thing, or he engages in conspiracy. Not here, criminal conspiracy is not here. Only a conspiracy with 1 or more persons for the doing of that thing, and not only that, and if an act or illegal omission takes place for doing of that thing, in order to doing of that thing. Thirdly, intentional aids. What is intentional aids? Suppose 2 persons are fighting. They are in anger mood one person, A and B are fighting, and they are they are losing, they have also lost their temper, and somebody just threw a knife. So that is intentional aiding a person, and somebody took that knife and caused a death, caused murder. So here that will also intentional aiding somebody. So illegal omission means what? Suppose a police officer is standing in the presence of police officer, two or more persons they are quarreling, and one of the persons committed an offence against the other. So here the police officer will be liable as per the provisions that is under section 107. That is, it will be treated as abatement because it is an illegal omission. It was his duty to prevent those persons from committing offence. Because of his act, because of illegal omission, it amounts to the abatement. So in this, you might have seen in the picture that is Palghar case, the police officer is standing that he has a duty to prevent. So sometimes the abatement section is also applicable there. So what it says that what is abatement? Abatement of a thing, firstly, if a person instigates another to do something or engages in a conspiracy, agreement, or meeting of mind, two or more persons, they conspire, engages in a conspiracy with one or more person for doing of that thing, and in order to doing of such thing, an act or illegal omission take place, then only it will be treated as abatement. Thirdly, if a person intentionally is what is very, your intention must be there, or by an act or illegal omission, the doing of that thing. So this explanation, a person who by willful misrepresentation or by willful concealment of a material fact which is bound to disclose, voluntarily causes or promises or attempts to cause or promise a thing to be done, is said to instigate the doing of that thing. A person who by willful misrepresenting somebody or by willful concealment of a material fact which is bound to disclose, voluntarily causes or procures or attempts to cause or procure, procures or attempt to cause or procure a thing to be done because of misrepresentation, because of willful misrepresentation or willful concealment of a material fact which is bound to disclose, voluntarily causes or procures or attempts to cause or procure a thing to be done, is said to instigate the doing of that thing. Illustration will make you clear. A public officer is authorized by a warrant from a court of justice to apprehend Z. B, knowing that fact and also that C is not Z, willfully represents to A that C is Z. Because of willful misrepresentation, that person, this B caused the arrest of another person, and thereby intentionally causes A to apprehend C, cause the arrest of C. So here he has abated the offence. So what he says, that is causes A to apprehend, here B abates by instigation the apprehension of C. See, explanation makes you clear that if a person by willful misrepresentation or by willful concealment upon a fact, material fact, which is bound to disclose, voluntarily causes or procures or attempts to cause or procure a thing to be done. In this explanation, the illustration will make you clear that A knows that B is not C, but he identified B as C and thereby caused his arrest by the police. So here that is also caused as instigation. The explanation too, whoever either prior to or at the time of the commission of an act, prior to the commission of an act or at the time of commission of act, does anything in order to facilitate the commission of that act, in order to facilitate at the before the act, before the commission of the act, or at the time of commission of the act, that he facilitated the commission of that act, and thereby facilitate the commission of thereof is said to aid the doing of that act. Aid the, well, intentionally aids. Suppose two persons are fighting, that they are in angry mood, and a person just threw a knife or threw some weapon, and that weapon, one of them picked up that weapon, caused hurt to another person. They are intentional aids. So these two expressions, willfully misrepresenting somebody, willfully or concealment. If a person causes a thing to be done, that will also be treated as instigation. So here expansion to, when a person, whoever, either prior to or at the time of commission of the act, prior to the act or at the time of commission act, does anything in order to facilitate the commission of that act, and thereby facilitate the commission thereof, is said to aid the doing of that act. So now you are clear what is abatement. Abatement may take place in three ways. First, by instigation. Second, engaging in conspiracy, and because of that conspiracy with other, any act or illegal omission takes place for committing that, for doing of that conspiracy, for doing of that thing. Thirdly, intentionally aiding, or by intentional illegal omission, the doing of that thing, that is, he occurs, or that thing happened. So in such case, that will be treated as abatement. So now you are clear what is abatement. Abatement means three ways: instigation, intentional instigation. That's you may find a case of mere the suicide. Somebody makes a suicide note. That will not be enough to hold somebody guilty that he has abetted the commission of an offence. That may be taken as an evidence, but that from that it will not prove that there is abatement of suicide. So what is section? Now section 108 says, who is an abater? Abater, a person abates an offence who abates either the commission of an offence or the commission of an act which would be an offence. So abater, once we say, when there is an abatement for committing an offence or for doing an act which would be an offence, then the person who abates if committed by a person capable by law of committing an offence with the same intention knowledge as that of the abater. So a person is said to be abate an offence. When a person is said to be abate an offence, a person abates the commission of offence, who abates either the commission of an offence, abate the commission of offence, or the commission of an act which would be an offence, who abates the commission, abates in three ways. Abate the commission of doing of an act which will be treated as an offence if committed by a person capable by law of committing an offence with the same intention or knowledge as that of the abater. The explanation one: the abatement of the illegal omission of an act may amount to an offence, although the abater may not himself be bound to do that act. So even there is an illegal omission, even the abater is not bound to do that act, but he instigates somebody to commit and do some illegal omission. That will thereby a thing takes place. Then that will also be, he will be treated as an abater. To constitute the offence of abatement, it is not necessary that the act abated should be committed. It is very important. Somebody instigated B to commit murder of C, but B did not commit the murder. Still then, A committed the abatement of murder, because it is not necessary that the commission of the offence is not necessary. What it says? To constitute the offence of abatement, this explanation 2 says, to constitute the offence of abatement, it is not necessary that the act abated should be committed, or that the effect requisite to constitute the offence should be caused. Even if the act is not done, even if the no effect requisite to constitute the offence was caused, still it will be treated as abatement. So if somebody simply instigates another or engages in conspiracy, criminal conspiracy to commit an offense, that will also be treated as an abatement. So what it says, to constitute the offense of abatement, it is not necessary that the act abated should be committed. Sometimes you may be in a misconception that unless an offense is committed, how a person will be made liable. Because here the guilty intention of somebody is to be punished. So this is so for the constitute the offense of abatement of an offense, it is not necessary. To constitute the offense of abatement, it is not necessary the act abated should be committed or that the effect requisite to constitute the offense should be caused. Illustration: in A instigates B to murder C. A instigates B to murder C. B refuses to do so, but B refuses to commit murder of C. A is guilty of abetting B to commit murder. So in this case, A is, so you should always remember that if a person abets something, abet for the commission of an offense, even if that offense is not committed, still he is guilty of commission for the offense of abatement of that offense. That is the section 108. Now, A instigates B to murder D. Now, another illustration: A instigates B to murder B. B, in pursuance of the instigation, stabs D. B, in pursuance of that instigation, stabs D. D recovers from the wound. So, A is guilty of instigating B to commit murder. Even if, so that explanation 3, it is not necessary that the person abated should be capable by law of committing an offense. This explanation makes it clear. Suppose a person instigates a child to just throw poison on the to the food of another, in order with an intention to commit his murder. Here, though the child is incapable of committing, below 7 years is not incapable of committing a crime, still the person who abets, he is liable for the offense of abatement of murder. What it says? It is not necessary that the person abated should be capable by law of committing an offense. If an insane person, he is abated, somebody instigated an insane person to set fire or to a house, and that consequently that insane person set fire. So here the person who abated, though that insane person is not guilty for any offense, because he doesn't know the nature and consequence of the act, but the person who instigated that insane person, he is liable for abatement of committing mischief by fire. Or that he should have the same guilty intention or knowing as that of the abater. It is also not necessary that the person who not necessary that the person abated should have the same intention or knowledge as that of the abater, or any guilty intention or knowledge. It is not necessary that the person who is instigated, the person who instigates, who abets, he is called abater. The person, it is not necessary the person who is abated, he must have same intention or knowledge that of the abater, or that guilty intention or knowledge that of the abater. There are number of illustrations in this section. If you go through the illustrations, you will be more clear in the matter, clear on the section. What it say? Illustration: A with a guilty intention abets a child or a lunatic to commit an act which would be an offense if committed by a person capable of law of committing an offense. A with a guilty intention abets a child or a lunatic to commit an offense if committed by a person capable of committing an offense and having the same intention as A. Here A, whether the act be committed or not, is guilty of abetting an offense, but the lunatic or child is not guilty for that offense. A, with the intention of murdering Z, instigates B, a child under 7 years of age, to do an act which causes Z's death. Suppose A instigates a child to put poison, yeah, to the food of somebody, and that child, because of instigation, he poisoned that food, and somebody took that food and he died. So here, this A is also that the person who abets is also liable for abatement of murder. A with the intention of murdering Z instigates B, a child under 7 years of age, to do an act which causes death. B, in consequence of the abatement, does the act in the absence of A and thereby causes Z's death. Here, though B was not capable by law of committing an offense because a child below 7 years commits no offense, A is liable to be punished in the same manner as if B has done, B has been capable by law of committing an offense and had committed murder, and he is therefore subject to the punishment of death. A instigates B to set fire to a dwelling house. B, in consequence of the unsoundness of his mind, B, incapable of knowing the nature of the act, or that he is doing what is wrong or contrary to law, sets fire to the house in consequence of A's instigation. B has committed no offense, but A has committed the abatement of setting fire to the dwelling house and is liable to be punishable for the provider for that offense. A intending to cause theft to be committed, A intending to cause theft to be committed instigates B to take property belonging to Z out of Z's possession. A induces B to believe that the property belongs to A. A instigates B to commit a theft and creates a belief in the mind, conceals something in the mind of that B, that the property belongs to him. A induces B to believe that the property belongs to A. B takes the property out of Z's possession in good faith, believing it to be A's property, believing it to the A's property. So here, B acting under the misconception does not take dishonestly, does not take this because A instigated B to commit theft of the property of Z. But while instigating B, A created a belief in the mind of B that the property which would be taken that belonged to A. So B, believing that the property belonged to A, took that property from the Z's possession. So in such case, though B is not guilty for any offense because there was a misconception. He did not know that the property belonged to Z. So he is not liable for any offense, but A is guilty of abating theft and is liable to the same punishment as if B had committed theft. Explanation 4. The abatement of an offense, being an offense. Abatement of an offense is one way. Similarly, the abatement of such an abatement is an offense, but abatement for abatement is also treated as an offense. That is explanation 4. The abatement of an offense, being an offense, abatement offense is an offense. The abatement of such an abatement to abatement offense, that is also an offense. Illustration, A instigates B to instigate C to murder Z. A instigates B, that is abatement. B to instigate C, A instigates B to abet C to murder Z. B accordingly instigates C to murder Z, and C commits that offense in consequence of B's instigation. B is liable to be punishment for his offense with the punishment for the murder. And A is instigated B to commit the offense. A is also liable to the same punishment. A, he who abets the commission of an abatement of an offense, is also, that will be treated, is also as an offense. Explanation 5. It is not necessary to the commission of the offense of abatement by conspiracy that the abater should concert the offense with the person who commits it. Concert must be in friendly, that he will present. That is, it is not necessary to the commission of the offense of abatement by conspiracy that the abater should concert the offense with the person who commits. That means X engages in conspiracy with another and B conspired with another. And it is not necessary that A must be consent to the other person who committed that act. It is sufficient if he engages in the conspiracy in pursuance of which the offense is committed. It is very important. Explanation size engages. Simply he may not be present at the time of the other person who committed. Illustration will make you clear. A consorts with B a plan for poisoning Z. A and B agreed, consort joined, that made a plan for poisoning Z. It is agreed that A shall administer the poison. It is agreed that A shall administer the poison. B then explains the plan to C. C was not present when A and B conspired for poisoning Z. But B then explains the plan to C, mentioning that a third person is to administer poison. Mentioning made a plan to C, mentioning that a third person will administer poison, but without mentioning A's name. He had not mentioned A's name. That B did not mention A's name to C that they had a plan for poisoning Z. C agrees to procure the poison and procures and delivers it to B. C agreed. C procured the poison and delivered to B for the purpose of his being used in the manner explained. A administers the poison. Here A administers the poison. Z dies in consequence. Here though A and C have not conspired together. A and C had no conspiracy. But A and B had conspiracy. B made conspiracy with C and C procured poison and thereby Z was killed. Here though A and C have not conspired together, yet C has been engaged in the conspiracy. Here C is engaged in the conspiracy in pursuance of which Z has been murdered. C has therefore committed the offense defined in this section and is liable to the punishment for murder. So this section in this chapter, this abatement, the section 107 and 108 are very, very important provisions. These provisions, if you have understood these fundamentals of these two sections, then it will not be difficult for you to understand the other provisions. Other provisions are only penal provisions. So here, 107, what is abatement of a thing, and 108, what is abator. And in this context, the explanations provided in section 108 are very, very important. Once you know the explanation and you go through this illustration meticulously or very carefully, then your concept will be clear. Once this is abatement, sometimes we skip up this section. Section 107 is simply, if a question is put, what is abatement? You know, if a person instigates another person to do a thing, that is abatement. But you do not understand that if a person engages in a conspiracy with one or more than one person, and in pursuance of such conspiracy, any act or illegal omission takes place for doing of that thing. Thirdly, if intentionally, sometimes you also omit intentionally. Intentional aids or illegal omission. Illegal omission is very important because if a person, I am standing here, two or more persons, they are fighting, and one of them caused the murder of another. I am not liable as an abettor because it is not my duty to prevent their fight. But a police officer is present there. It is his duty to prevent the offense. If he omits illegally, then he will be liable as an abettor. As per the provision, he will be treated as an abatement. He will be an abettor as per section 108. That is, he instigates, he abets the doing of that offense. So that is very important if illegal omission takes place. Illegal omission, the doing of that thing. So that further, you must know, if by willful misrepresentation or concealment of certain facts, if a person which is bound to disclose voluntarily causes or procures the doing of a thing and said to instigate the doing of that thing. Then explanation 2 also, if prior to the or at the time of the commission of an act, if a person does anything in order to facilitate the commission of that act and thereby facilitate the commission thereof, do some facilitative and thereby facilitate, the commission is said to aid the doing of that thing. You should understand. Now, The other provisions are that is punishment provisions. 108A, abatement in India offence outside India. This is a person abets an offence within the meaning of this code, who in India abates the commission or offence act without being. If a person abets in India to committing a murder in Uganda or in England, so if that will be constituted an offence in India, then 108A will be treated as if he is liable for that. A person abets an offence within the meaning of this code, within the meaning of this Indian code in India. A person abets an offence within the meaning of this code who in India abet the commission of an act without and beyond India. A person would constitute an offence if committed in India. If a person abets the commission offence outside India, if that offence which is committed outside India, that is also treated as an offence in India, then that will be treated that he has abetted that offence in India. That 108A, that is what it says. A person abets an offence within the meaning of this code, within the Indian Penal Code. In India, if a person abets the commission offence in India, if he abets the commission of an act without and beyond, if he abets the commission upon any act, not an offence, a commission of an act beyond India, if that act is punishable as an offence in India. So, A in India instigates B, a foreigner in Goa, to commit a murder in Goa. Suppose because Goa was previously not part of India, A in India instigates B, a foreigner in Goa, to commit a murder in Goa. A is guilty of abatement of murder. Now, section 109 onwards, we find punishment. The prescribed for abatement. Punishment, there is some punishment when offence is committed, then the punishment is more. When offence abated is not committed, then maybe punishment, in some cases, the punishment is less. So, section 109 provides punishment of abatement if the act abated is committed in consequence and where no express provision is made for its punishment. There are certain sections in the Indian Penal Code which provides that abatement of a particular offence, there is express provision for punishment. When there is no express provision for punishment for abatement of an act, if it is committed in consequence of that act, then what will be the punishment that has been provided in section 109? What it says? Whoever abets any offence shall, if the act abated is committed in consequence of the abatement. So the person who abated the commission of offence and the act abated is committed, that in consequence of that abatement an offence is committed and no express provision is made by this code and no express provision by this code for the punishment of such abatement. If a person abets the commission of offence and that offence is committed and there is no express provision in the Indian Penal Code for punishment, then in such case he be punished with the imprisonment provided for the offence. What is offence? The sentence which is prescribed for the offence, he will be punished with the same sentence. What is section 109 says? If and there is an abatement of an offence and that offence is committed and there is no express provision in the Indian Penal Code for punishment for such abatement, then in such case the person abator will be punished with same sentence as provided for the offence. An act or offence is said to be committed in consequence explanation abatement when it is committed in consequence of the instigation or in pursuance of the conspiracy or with the aid which constitute the abatement. So an act or offence is said to be committed. So an act or offence is said to be committed. When act or offence is committed, because of such it is consequence of instigation, consequence of some conspiracy, or with the with the aid of, or if that act is committed, so it will be treated as if that offence has been committed because of abatement. So illustration: A offers a bribe to B A offers a bribe to be a public servant as a reward for showing A some favor in the exercise of B's official function. B accepts the bribe. A has abated the offence defined in section 160. Now, no longer 161 IPC that has been repealed in view of the Prevention of Corruption Act, passing of the special law, that is Prevention of Corruption Act. So A instigates B to give false evidence. B, in consequence of the instigation, commits that offence, gives a false evidence. So here A is guilty of abating that offence and is liable to the same punishment because there is no express provision in the Indian Penal Code for, for abatement of this giving false evidence. A and B conspires to poison Z. A, in pursuance of the conspiracy, procures the poison and delivers it to B in order that he may administer it to Z. B, in pursuance of the conspiracy, administers the poison to Z in A's absence and thereby causes Z's death. Here B is guilty of murder. A is guilty of abating that offence by conspiracy and is liable to the punishment for murder. That is section 100. Most of the cases you find section 100. That is, in the when section 109 provides that when there is no express provision in the Indian Penal Code for prescribing punishment for abatement of an offence, if the abatement, if a person has abated the commission of an offence and that offence has taken place, in such case, that abater will be liable for the same punishment as prescribed for the offence. This is section 109. 110 says, punishment of abatement if person abated does act with a different intention from that of abater. Punishment of abatement if person abated, the person who abated the doing of that, he does an act with different from the intention of the abater. Whoever abate the commission of an offence shall, if the person abated does the act with a different intention or knowledge from that of the abater, be punished with the punishment provided for the offence which would have been committed if the act had been done with the intention or knowledge of the abater and with no other. Suppose A abated B to commit murder, but B did not commit murder, but B caused, say, grievous hurt to that person. A abated B to commit murder of C, but B caused grievous hurt to C. So in such case, this A will be also liable to be punished as if that murder, that means be punished with the punishment provided for the offence which would have been committed if the act had been done with the intention or knowledge of the abater and with no other. So the offence under this section, according as the offence abated is cognizable and non-cognizable, and accordingly to the offence abated is bailable or non-bailable. Now section 111, liability of abater when one act abated and different act is done. Suppose the abater has abated one act, but a different act is done. In such case, when an act is abated and a different act is done, the abater is liable for the act done. So in the same manner and to the same extent as if he had directly abated it, provided the act done was a probable consequence of the abatement, and was committed under the influence of the instigation. Suppose a person has abated, A abated B to cause simple hurt to C, but B that caused a grievous hurt. So in such case, but the person is also, so when an act is abated and a different act is done, the abater is liable for the act done in the same manner and to the same extent as if he had directly abated the grievous hurt. Provided that the act done was a probable consequence of the abatement. Suppose he had abated B to cause hurt to him, cause hurt to C, but B entered into C's house and committed theft. So that for that the abater will not be liable because that is not the probable consequence of the abatement. So if suppose a abatement is there to cause simple hurt, but a grievous hurt was caused or a murder was caused, in such case, then abater will be liable as if he had directly abated the incident. Because provided the act done was a probable consequence of the abatement and was committed under the influence of the instigation or with the aid or in pursuance of the conspiracy which constituted the abatement. Illustration: A instigates a child to put poison into food of Z and gives him poison for that purpose. Sometimes you get a direct question that is a problem on this. A instigates B, a child to put poison into the food of Z and gives him poison for that purpose. The child, in consequence of the instigation by mistake, put the poison into the food of Y. The child put that poison in the food of Y, which is by the side of that of Z. Here, if the child was acting under the influence of A's instigation, the child was acting under the influence, and the act done was under the circumstances, a probable consequence of the amendment is liable in the same manner and to the same extent as he had instigated the child to put the poison into the food of Y. So, because when the child has been instigated to do a particular act, but he did another thing under the influence of such abatement, and because of such offense is committed, then the abater will be liable directly as if he has abated the commission of that act. A instigates B to burn Z's house. B sets fire to the house and at the same time commits theft of property therefore. It is another problem. A instigates B to burn Z's house. B burns Z's house or committed theft property from there. A, though guilty of abating the burning of the house, he is not guilty of abating the theft. For the theft was a distinct act and not a probable consequence of the burning. You should know. A instigates B and C to break into an inhabited house at midnight for the purpose of robbery and provides them with arms for the purpose. B and C break into the house and being assisted by Z, one of the inmates murdered Z. Here, if the murder was the probable consequence of the abatement, A is liable to the punishment provided for murder. This is very, very important. These provisions, liability of abater when one act abated and different act. That means the different act was the probable consequence of the act abated and was committed under the influence of such instigation. Then in such case, the abater will be liable, or with the aid or pursuance of the conspiracy, then in such case the abater will be liable to the extent as if he had directly abated. This section 111 you should understand. In the next class we will discuss the other provisions regarding abatement. Thank you all.